Hi there, I'm Kelly Longtin, and welcome to our YouTube channel. In this segment, we're going to talk to you about do not let your money and property go to the state and why you need an estate plan. Now, Americans tend to bristle when any level of the government meddles in their private lives, especially with their money. Look no further than the famous death and taxes quote to sense how Americans feel about bureaucratic creep and government's sticky fingers. You may take pains to minimize government meddling in your personal affairs during your lifetime, but if you do not have an estate plan, you may die intestate, and state law will become heavily involved in what happens to your money and property. It may even end up claiming it for itself through a process called escheat. To avoid these outcomes, you need to have an up-to-date estate plan that lets you exercise maximum control and autonomy both in life and in death. Let's talk about escheatment and the state's taking power. Escheat is a term that dates to feudal times when if a tenant died with no blood relatives, their estate reverted to the lord of the manor as the ultimate landowner. Middle English referred to this practice as escheat, which evolved into our modern state escheatment laws. Today, every U.S. state laws requiring unclaimed or abandoned property be turned over to the state after a designated period of inactivity called the dormancy period, which typically ranges from 1 year to 5 years, depending on the state. Unclaimed property can be tangible or intangible and include assets such as 401ks, inherited individual retirement accounts, taxable investments, bank savings, and other financial assets and accounts that have been inactive for a while and are legally deemed to be dormant. Unclaimed property also includes life insurance proceeds and assets such as gift certificates, uncashed checks, and personal property held in safe deposit boxes. States hold billions of dollars in unclaimed property taken by escheatment. Unclaimed property is a major source of revenue for some states. It's the fifth largest funding source for California, for example, and the third largest funding source for Delaware. So let's talk about escheat and intestacy. A 2025 Caring.com survey found that just 24% of Americans have a will. Put another way, 3 out of 4 Americans are likely to die intestate because of their lack of preparation. Both scenarios can ultimately lead to the state claiming your money and property after your death through escheatment proceedings in probate court. If you pass away and do not have a legal document such as a will or a trust that clearly identifies who should receive your money and property, you are said to have died intestate. If you die intestate, state laws called intestacy statutes will determine who inherits from you. These laws generally start with next of kin, but if there are no family members to receive your money and property could end up going to the state instead of supporting your non-family loved ones or a favorite charity. This practice, a throwback to feudal times, essentially makes the state the default heir, the lord of the manor, and you a mere tenant. Another possibility is partial intestacy, which occurs if you die with a valid will, but the will does not fully address everything that you own. Intestacy rules will apply to those remaining accounts and property. Now, if you want something different, you have to update your plan. It's not only dying intestate that can trigger state escheat and intestacy laws. You can have an out-of-date or incomplete plan that fails to include a comprehensive inventory of everything you own. Because loved ones might not have a full picture of what you own or where to find it, those accounts and property could be unclaimed for several years and ultimately end up in state custody. In other words, a good estate plan leaves a trail of breadcrumbs for your executor or trustee to follow so they can identify, gather, and distribute everything you own, leaving nothing behind for the state. A comprehensive estate plan also lets you take control and decide exactly who inherits what. Estate planning allows for nuances that state laws do not and can make all the difference between crafting an intentional legacy and being subject to the state's default legacies for you. Now, some scenarios that an estate plan can address and state law cannot include the following. first is stepchildren. Under most intestacy laws, stepchildren do not automatically inherit anything unless you've legally adopted them. If you raise a stepchild as your own and you want them to inherit, you will need a will or a trust to make that happen in most states. Now, for unmarried partners, in most states, unmarried partners have no legal right to each other's money and property under intestacy laws, regardless of how long they've been together. This can result in a situation where a long-term partner is left with nothing, while estranged relatives or state claim the money and property that have been left behind. If you have a close friend, intestacy laws do not recognize friendships. To leave something to these very important people in your life, you must spell it out in your estate plan. Now, what about charity? You may prefer that your money go to a cause that you're passionate about, such as animal welfare, education, or medical research. Charities will not see a dime unless you explicitly designate them as beneficiaries. And then specific request. Want to leave your antique watch to your nephew or your art collection to your niece? Intestacy laws distribute money and property generally and do not carve out gifts of specific items. You also want control over guardianships. A will allows you to nominate a guardian to care for your minor children. Lacking this crucial designation, the court will decide without input from you, and the person they select may not be your preferred choice. Now, you want to take control with an estate plan. Legal jargon such as escheat and intestate may put people off from the estate planning process entirely. Even the term estate can suggest an inclusive service only for the wealthy. In reality, estate planning is for anyone who owns anything of value, monetary, sentimental, or otherwise, and who cares about what happens to it. Delaying estate planning can cause conflicts in your family. If you want to exercise maximum control over your hard-earned money and property and ensure that the state does not end up claiming it, you should have at least a basic will. However, you can exercise even greater control and likely avoid probate court altogether with a trust-based estate plan. Do not settle for the state's default rules and leave things to chance or the government. Take charge of your legacy today. So meet with your local estate planning attorney to make sure that you put an effective estate plan in place. I want to thank you for watching. Please like and subscribe our page below so you can keep up to date on new videos, new education about estate planning and how it can benefit and influence your family.